And so perhaps it's a shame that on his death, in part because the Golden Rule wasn't followed, there was a testamentary probate dispute about his estate. I'm not going to focus on the Golden Rule today, first of all because I'm assuming that you're all familiar with it and don't need to be told by me that that needs to be followed when you're dealing with an aged or infirm testator. So what I'm going to be talking about instead is the other thing these two cases have in common, which is that they focus on the insane delusions limb of the familiar Banks and Goodfellow test. So before I go into the facts of the individual cases, I thought it would be helpful to, by way of a reminder, run through a bit of background on the insane delusions limb. I've put the quote up there, the famous quote from Banks and Goodfellow on the slide, expressed in impressive 19th century prose, but of course been subject to several modern paraphrases. But the two most important limbs of it are the first one there, that no insane delusion shall influence the testator's will when disposing of his property and bring about a disposal of it which, if his mind had been sound, it would not have been made. And a little bit more detail is then provided in the second quote I've set out there as to what exactly is meant by that. But I think it's important, before we go into the cases, to draw out some features of insane delusion cases and really how difficult it is to establish this ground of challenge to a will. Now, famously, it's not good enough that the testator was unfair or mean when they made their will, because of course we have testamentary freedom in this country and you can be as unfair and capricious as you like. So the mere fact that the testator took a very unfair or unduly harsh view of a would-be beneficiary is not going to be good enough. The second point that needs to be emphasised is that it's not good enough by itself that the testator suffers from delusions. The delusions in question have to be causative. I've mentioned there the case of Lloyd and Jones. In that case, the court accepted evidence from the members of the family that the testatrix sometimes expressed the delusion that aliens or witches were landing on her farm, or that Saddam Hussein had broken in. So however bizarre those beliefs might be, and however clearly they're the product of some sort of delusion, there was no causative connection in that case between the delusion she had, the aliens and Saddam Hussein, and the will she made. So, as I've said, the delusion has to be causative, and I put up there a clear case of a case where the delusion was causative. That's the case of Costick and Chaplin. And in that case, the testator left his entire estate to the Conservative Party Association. Now, that's not by itself evidence of insanity, but the reason for his disposition, as it emerged on the evidence, was that he believed that there was a sinister and highly organised international conspiracy of dark forces assembled against him. Crucially, he believed that his family members were implicated in that conspiracy. And a related delusion was that only Mrs. Thatcher could save the country from the bestial monsters by whom he was being pursued. So that led Mr. Justice Henderson, as he then was, to conclude that it was impossible to keep his support from the Conservative parties, who had benefited from the will, and his delusional belief system in separate watertight compartments. And so Mr. Justice Henderson pronounced against the will, because in that case, the insane delusions, both about the family members and about Mrs. Thatcher, had led him to make the will in the terms that he did. And the final point to make is it's not going to be good enough either that the testator has been saying things to all and sundry about her children, in that case, the case of Ree Ritchie, which turn out to be untrue. She also has to believe that they're untrue. So she's not just lying about her children and what she says to third parties. She's actually formed a false belief about what they did. So that's a bit of background to insane delusions, and I hope it's clear from that summary that this is not an easy ground of challenge to succeed on. You need to have those insane delusions, and I guess they're obvious when they're there, but you also need to be able to show the link between those delusions and the will. And so in a case where the testator has perhaps preferred one child to another, you'd have to show that it wasn't just an arbitrary, capricious or mean choice. You'd have to show that it was caused by the insane belief that they had formed. So having set out that background, Clitheroe and Bond. In that case, the testatrix was a lady named Jean. She had 3 children, one of whom had predeceased her, but she was survived by her son John, the claimant, and he was propounding the last will in that case, and by her daughter Sue, the defendant, who was challenging the last 2 will. And the reason that she was doing that is because under both of those wills, Sue had been largely excluded and John took residue. And I should note there that these were professionally prepared wills, and that the solicitors who prepared the wills didn't decide to follow the golden rule in that case, which is perhaps unfortunate. Now, the claimant, John was the claimant, but Sue, the person challenging the will, was assisted because Jean, the testatrix, had left really quite detailed explanations for why she was making the will in the way that she was. And these were recorded in the instructions for the will and in the attendance notes that were prepared by the solicitors. So she alleged that Sue was a shopaholic or a spendthrift. And so the implication is that if she was left a large sum of money, she would fritter it away. She also alleged that there was a lack of contact, both with Sue, her daughter, and also with Sue's daughter, Jean's granddaughter. And she laid that at the feet of Sue. And finally, there were issues that related to the estate of her earlier deceased child, named Debs. And she made various allegations to do with that. And these related to whether or not Debs had made a will, and also to whether Sue had, quote, ransacked Debs's house following her death. So you can see that against that background, there was quite a lot for the court to deal with. And so the primary allegations in terms of legal analysis made by Sue were first that John had perpetrated a fraudulent calumny. That's the sort of poisoning of the mind where you deliberately or recklessly tell falsehoods to a testator to get them to change their will. Now that's an interesting ground in its own right, but it's outside of the scope of today's talk, so I'm not going to focus on it. Suffice to say that that ground of challenge was unsuccessful. However, I do want to note that by alleging fraudulent calumny, that John had been poisoning Jean's mind, a lot of evidence was therefore an issue, including on the disclosure of medical records, that perhaps might not have been an issue if Sue had focused solely on lack of testamentary capacity. I'll explain that a bit when we come on to the question of the delusions. But suffice to say that the allegation that John had put false ideas into Jean's mind and the allegation that Jean had false ideas in her mind actually ran very closely in parallel in that case. And it may, and I don't put any higher than that, but it may have assisted Sue that those allegations were in play, even though fraudulent calumny is among the most difficult grounds of testamentary challenge to establish. So as I said, the fallback position that Sue had was that Jean was suffering from a complex grief reaction which stemmed from the time of her daughter Debs's death, and that led to the insane delusions regarding Sue. And suffice to say, Sue denied all of those suggestions made by Jean about her character, about her shopping habits, and about what had happened with Debs's estate. And as everyone will recall, in the Key decision, it was established that a depressive episode or disorder, in that case arising from the death of a loved one, may be an appropriate disorder of the mind, which can lead to a finding of a lack of testamentary capacity. So Sue was relying on Key to show that this grief reaction, which was associated with the death of their daughter, had in fact caused these insane delusions that Jean was suffering from. So I'm going to pause there and note the burden of proof in relation to findings of insane delusions. Because you might think it's a bit like fraud. You actually have to prove positively that they had this insane delusion and that it was causative. But in fact, the position's a little bit more nuanced than that. And this was present in the Costick and Chaplin case and in the earlier case of Smee and Smee, and I've put the quote up there on the slide. And the way it was put by Mr. Justice Henderson in Costick and Chaplin is that once the person challenging the will has got over the initial threshold of showing that somebody was suffering from insane delusions, once that's established, the burden falls back onto the person propounding the will to show that those insane delusions didn't cause the will to be made in the terms that it did. So it's a burden shifting problem. And that was important in this case. I mean, in probate cases, burdens of proof are enormously important, particularly where the evidence is incomplete. And it appears to have been decisive in this case. So having put that point out there about the burden of proof, let's look at the expert evidence. In this case, there was an expert on each side, and the practice of hot tubbing was followed. For those who are unfamiliar, this is a relatively new innovation in the civil courts, that rather than having the expert witnesses go one at a time and one responds to the evidence of the other, they both get put in the box in the sort of hot tub at the same time. They both have to answer the same questions, and the idea is that you sort of develop a collaborative approach between the experts, and it's thought in some quarters to produce better evidence that's more helpful to the court. Now, in this case, the usefulness is questionable because it appears that it was used simply because the judge was running out of time. So, query, but it's something to note for a future case. Do you think hot tubbing is going to be of assistance when you've got rival capacity reports, as you almost always will in any serious testamentary capacity challenge? Now, the reason I flagged the issue of the burden of proof in this case is that the evidence did not show that Jean didn't suffer from delusions, if that makes sense. John's expert established only that he wasn't able to conclude that she did suffer from delusions. And the court, having decided that the burden was on John as the person propounding the will, that was not good enough. And that was an important part of the evidential picture. Now, the other important part of the evidential picture, I'm afraid to say, is that John's evidence was comprehensively disbelieved. Now, there were a number of delusions in the part of Jean that were established, and I've set them out there on the slide. I want to just briefly dwell on the first one because it's of some importance and it really sets the other findings of insane delusions in context. It was a really sad and unfortunate history to this family. When Sue was a child, well, sorry, when Sue had been a child, she'd suffered sexual abuse at the hands of Jean's husband, and she had made Jean aware of that, and the eventual consequence of that was that the marriage broke up. And in particular, there had been a letter that had been written from the husband to Sue at the time, which made clear the kind of conduct that was going on then. And that evidence had been part of there wasn't a police report, but it had been part of the medical records that were consequent on everything that had gone on. And by the time that Jean came to make the will, she had, well, I'm not sure that forget is the right word. She no longer appreciated that the letter had been evidence of the sexual abuse that was going on. And she had formed the view that in fact Sue had been lying about all of this. And therefore that she had sort of maliciously broken up the marriage and was a home wrecker, which of course is an extremely unpleasant allegation for Sue to have faced. And of course the medical records, which were disclosed, firmly supported the position that Sue had put forward and showed that Jean's belief that this was all made up by Sue was delusional. And so the seriousness of that delusion, even though it wasn't what Jean focused on when she made her will, she focused on these issues which seem a little bit more minor, like the fact she was a shopaholic, and these allegations about the theft of property of very low value, like Swarovski crystals and troll dolls, and other small items. All of that has to be placed in a context where, on this really important and fundamental aspect of the underlying family dynamic, Jean had formed this delusional belief. But suffice to say, all of the allegations that I've put out there on the slide were found by the Deputy Master to be delusions. And the Deputy Master was satisfied, given the very clear evidence that this was why Jean had made the wills in the term that she did. The Deputy Master was satisfied that those delusions had caused her to make a will, effectively excluding Sue from benefit. Now, the reason I focused on that very serious allegation, the first bullet point, is because it might be thought that some of the other allegations, they're very hard for a party to show that they are delusional beliefs rather than simply a matter of opinion or perhaps an unduly harsh judgment from a parent. So the idea that someone is a shopaholic, there's a certain amount to which that's in the eye of the beholder, I would suggest, and you might reasonably have the opinion that someone's a shopaholic and somebody else would have a different opinion. So it might be thought that that by itself would be something that would have real difficulty overcoming the threshold for showing an insane delusion, even though it was those allegations that were the ones that were stated by the testatrix to be the ones that influenced the making of her will. So the conclusion in Clitheroe and Bond was that although fraudulent calumny failed and Sue didn't come up to proof in showing that John had been responsible for poisoning Jean's mind against her, those insane delusions, which I put up there on the slide, were sufficient to poison Jean's mind against Sue and lead her to make the will that she did. And so the last two wills which had been made by Jean were pronounced against. So that deals with Clitheroe and Bond. And at the end, I'm going to come back to some points arising which apply to both cases. The other case I wanted to talk about today is Templeman. This is the estate of Lord Templeman, known to the legal profession as a member of the Judicial Committee of the House of Lords and a noted Chancery practitioner. Lord Templeman died leaving a will made in 2008. He was survived by his two sons from his first marriage, Michael and Peter. He had been predeceased by both of his wives, including his second wife, Sheila, and Sheila had two stepdaughters from her own second marriage, who were the claimants in this case. Now, it's important, by way of background to this case, to set out a bit about the family property. So during the course in the time after her first marriage, Sheila had built a property called Mellowstone on a paddock adjoining one of her properties. And she'd lived there with her second husband. And then after her marriage to Lord Templeman, she lived there with Lord Templeman from the time of their marriage until Sheila died in 2008. And then under the terms of Sheila's will, Lord Templeman inherited Mellowstone. And to Lord Templeman, after that occurred, he felt that a great injustice had been done, because as he saw it, he'd inherited this property which, if you like, Sheila had brought into the marriage, and he wanted that property to pass to her stepchildren from her earlier marriage. And he was said to have said that this is not right, that something had to be done about this. And that led to his decision to change his will so as to pass Mellowstone to the claimants. So the position before the 2008 will was part of a joint will-making exercise between Sheila and Lord Templeman. And broadly speaking, in the event which happened, so if Sheila predeceased Lord Templeman, and he received Mellowstone under the terms of the will, he gave £20,000 each to his 6 grandchildren, gave a cash legacy to Sheila's residuary beneficiaries, and then split the residue of his estate between his 2 sons. So that was, and under that arrangement, his sons took the majority of his estate. Now, the big difference in the 2008 will was that Mellowstone, which was of course a valuable property, was bequeathed to the 2 stepdaughters, and the legacies to the grandchildren and to Sheila's residuary beneficiaries were removed. But the position as to residue was the same, but the size of residue, because Mellowstone had been taken out of residue, was much less. And as a consequence of that, one of Lord Templeman's 2 sons and the son's wife challenged the validity of the 2008 will, essentially on the basis of lack of testamentary capacity. But in the course of presenting the case, it emerged that the focus of that allegation of lack of testamentary capacity was that Lord Templeman was acting under an illusory belief. So the logic of the argument ran like this. Lord Templeman had in fact anticipated that he might inherit Mellowstone from Sheila and had provided for that eventuality under the terms of his 2004 codicil. So in that case, so he had thought about the possibility that he'd inherited Mellowstone and he'd provided for it. But then in 2008, after Sheila had died, he thought that this was not right, that he thought there was an unfair position, and he wanted to provide Mellowstone to the two stepdaughters. So the logic ran that he had either forgotten or did not appreciate that he'd already made provision for this by his earlier will, and that illusory belief provided a false premise for the will in 2008 that he made, which was more favourable to the two stepdaughters. So that illusory belief argument was the absolute centre of the son's case. And that informed, the next slide, that informed the expert evidence. Quite strikingly, for a case which was being put forward by somebody with experience of chancery practice, the defendants didn't introduce any expert evidence of lack of capacity. There was some passing reference to observations that had been made by Professor Jacobi, known to the profession as an expert in old age psychiatry, who happened to know Lord Templeman socially, that at around this time he had made some passing observations that Lord Templeman might be starting to suffer the symptoms of dementia. But beyond that hearsay evidence, there wasn't any evidence in the form of a contemporary expert report on behalf of the defendants. Now, for their part, the claimants propounding the will called upon Professor Howard, another noted expert in this area, who gave evidence that Lord Templeman was suffering from a mild degree of dementia caused by Alzheimer's disease, and I've set out on the slide how that would have affected Lord Templeman in 2008. But nonetheless, he retained testamentary capacity. Now, just pausing there, I mentioned the golden rule earlier and the sad irony that it wasn't followed in this case. Now, the defendants sought to argue that the very fact that Lord Templeman, the proponent of the golden rule, had not insisted that it was followed in his case was evidence that he lacked capacity. Now, suffice to say that Mr. Justice Fancourt did not find that argument persuasive. And in fact, the judge reached the opposite conclusion, that he would have had firmly in mind his own famous decisions regarding the golden rule, and would have decided not to seek a capacity report in that context. So the only expert evidence was that that he had testamentary capacity, which threw back the defendants entirely on the doctrine of illusory beliefs. And they in particularly relied on a case called Re Bellis, an early 20th century case. Now, in that case, Mrs. Bellis had wanted to put the provision for her two daughters on an equal footing. The logic was that she'd provided much more for one of her daughters than the other during her life, and she wanted to even things up. Now, in fact, she was operating under a completely false idea as to what she had done in the past, and so the will that she ultimately made completely failed to put her children on an even footing. In fact, it achieved the opposite. Now, on the basis of the evidence available in that case, the court concluded that Mrs. Bellis lacked testamentary capacity because the belief that she had about what she'd done in the past directly affected the will that she went on to make. And this should be ringing bells about the test of insane delusions. Now, Re Bellis hasn't been applied more broadly than that. So there is a question, before Templeman case at least, as to how broad the principle goes. And I think it's fair to say that the defendants in the Templeman case were seeking to argue that it had a wider application and supported the suggestion that a mistaken belief, without more, could be grounds for invalidating a will. And one has in mind the doctrines of mistake in unilateral or bilateral agreements. And so it was sort of being argued for as establishing a freestanding ground of mistake in the context of wills. Now that argument has now been firmly shut down by Mr. Justice Fancourt in Templeman. And it had also been strongly doubted by the decision of His Honour Judge Matthews in the case of Ball and Ball, effectively on the same grounds. Now, the two passages I've set out there on the slide bear close inspection. So explaining the outcome in the Bellis case, Mr. Justice Fancourt held that Mrs. Bellis did not have the mental powers to enable her to recall and understand the true dealings between herself and her daughters. So this wasn't a mistaken belief that was capable of being corrected. It was an illusory belief that she could not be shaken of, and it deprived her of her reason. So he rejects the suggestion that there's some wider doctrine of mistake. He goes on to hold, and this is important for the talk I'm giving today, that the phrase illusory belief wasn't a synonym for mistaken belief, but it was the kind of fixed belief, similar in character to an insane delusion, which the testator does not have the mental powers to overcome. So this appears to be explaining the decision in Bellis, not in terms of mistake, but in terms of a deluded belief which had so fixed itself in the mind of the testator that it affected their reason, their ability, their sound disposing mind. So on that basis, Mr. Justice Fancourt found that the will was in fact a valid will and should be admitted to probate. And so I want to draw this talk to a close with some practical points. I've already said that it's now clear that a mere mistaken belief expressed by the testator will not be good enough. You need something akin to an insane delusion. And similarly, I've pointed out that establishing insane delusions or illusory beliefs is going to be a high bar, and you really need the right factual evidence, and that's going to include lay evidence to establish that such a belief or delusion might have been present. Similarly, and this almost goes without saying, but I pointed out because there wasn't an expert report on behalf of the defendants in the Templeman case, where testamentary capacity is at issue, expert evidence is going to be virtually essential. And I would suggest you're going to want that expert evidence at an early stage, just so the parties can know what it's going to say. And in a low value claim, that might be a single joint expert. And when there's more money in issue, the costs would justify experts on each side, possibly with some hot tubbing. But that being said, these cases are intensely fact sensitive. The lay evidence is extremely important. And it's worth emphasising that the evidence of John in the Clitheroe case, the person propounding the will, was comprehensively disbelieved. So it helped the claimant, it helped Sue in that case establish her case on insane delusions, that everything that was being said on John's behalf about the conduct complained of by the deceased was found to be false, even though the court didn't go quite as far as holding that John was poisoning Jean's mind against Sue. So, as I've said at the outset, that these insane delusion cases are going to be hard to establish on the evidence, but where they're present, you can see how persuasive the kind of evidence that you had in Clitheroe and Bond might be. And it's worth emphasising that a lot of that evidence appears only to have come out after the proceedings were commenced and there was disclosure of these historic medical records. And you had these rival accounts, for example, in relation to the historic sex abuse, that only the extraneous documents were able to corroborate on one side or the other. So interesting cases, and I think I wouldn't be surprised if we see more along these lines, because arguably a case like Clitheroe and Bond, in line with perhaps earlier cases like Re Ritchie, slightly lowers the threshold of the kind of delusions you need in order to establish a lack of testamentary capacity. Certainly a lot lower than the kind of delusions that were present in Costick and Chaplin, for example. That brings to an end everything that I was planning to say. And so I was going to look and see if there were any questions. And this is an opportunity, if you haven't submitted any questions yet, to put those into the Q&A box, and I'll try and deal with those. Let's have a look. Somebody has asked what happened with costs in Clitheroe, given the unsuccessful claim in fraudulent calumny. Now, I have to confess I don't know the answer to that. I don't think there's been a reported cost judgment in that case. But it's right to emphasise that if you make a serious allegation, including fraud, and you fail to come up to proof on that issue at trial, you face the consequences of that. So you might face an adverse costs order even if you're successful on another ground. And that's why it's such a double-edged sword. Now, in this case, obviously, that Sue was very clearly persuaded that John had been poisoning Jean's mind against her. But the evidence at trial suggested that, in fact, Jean had reached those illusory beliefs all by herself. So it's entirely possible that there would be an adverse finding on costs on the basis of the allegation of fraudulent calumny. Now, you don't have to allege dishonesty to allege fraudulent calumny, because your full statement can be made recklessly. It doesn't have to be made knowing that the statement is untrue, but it's still a serious allegation. And so it shows you why it's so difficult. And then there's an analogy here, of course, with undue influence. Notoriously, people often allege want of knowledge and approval when what they really mean is undue influence, because they're frightened of the cost consequences of alleging undue influence and then failing to prove it. So I think that deals with fraudulent calumny, and I would have serious reservations before advising someone to plead fraudulent calumny unless the evidence was really clear, because there are so many limbs to fraudulent calumny that you have to overcome. And not only do you have to show that the statements in question are untrue, so it's a bit like a mini defamation trial, you also have to show the intention, and you have to show either the dishonesty or recklessness, and you have to show the causative effect between the dishonest statement and the will that gets made. So that's a really hard evidential hurdle to overcome. So that's a reason by itself to be quite cautious about pleading fraudulent calumny, quite apart from the serious cost consequences of the allegations of fraud. So another questioner has asked, your guidance, presumably your guidance should be to follow the golden rule in all such cases where capacity in question. However, would doing so be definitive, or could a challenge still be raised? Yes, a challenge can still be raised if the golden rule is followed. The golden rule is a rule of best practice. The fact that a GP saw somebody in the time leading up to their death and formed the view that they had testamentary capacity is not going to be conclusive. Capacity is a medico-legal question, not a purely medical question, and GPs are not specialist capacity assessors, so there can be no certainty. But the intention behind the golden rule is to knock a lot of testamentary capacity challenges out at the first hurdle. And I think it's still a rule of best practice and should be followed, but it's not an absolute insurance policy, no. I think Re Ritchie is a case where the golden rule was followed, but nonetheless, there was still a challenge on the grounds of lack of capacity. So if anyone has any other questions, now is the time. Ruth from my chambers has asked, in 2020, is it satisfactory to have the burden of proof bouncing, given that the court in Gill did not approve of this in knowledge and approval? So in the case of Gill, knowledge and approval, the court didn't like the approach of saying, are there suspicious circumstances and can the claimant overcome them? But nonetheless, that there should be a single composite test. But I think it's acknowledged that really, whether you view it as a two-stage test or a single-stage test, you're going to reach the same outcome, one way or another. Now, that being said, I think that there's a stronger ground for arguing in terms of the burden shifting in relation to fraud, in relation to insane delusions, because it actually mirrors the position with the burden of proof on testamentary capacity more broadly. In the party alleging lack of capacity has to raise a prima facie case of lack of capacity, but if they do so, the burden will shift onto the person propounding the will, because the burden does start with the person propounding the will to show testamentary capacity. So I don't think it's that unusual to have that burden shifting. And of course, the burden shifting was really important in Clitheroe and Bond, because the expert evidence that was adduced was not good enough to show that she didn't have the insane delusions in questions. So one final question, and then we'll draw things to a close. Gavin asks, in the event that capacity was borderline, but the testator was close to death, such there was no time to arrange a doctor for the golden rule, would it be best to execute the will and make a note of the circumstances, or not execute the will? I think the answer has to be execute the will, because you'd probably be negligent if you didn't. So the golden rule is a rule of best practice. It isn't followed in all cases. The opinion of an experienced solicitor as to whether there is testamentary capacity is always going to be persuasive and will always carry weight. So if you are faced with somebody who is dying, there's some dicta from Mr. Justice Neuberger, as he was in first instance, suggesting that nothing longer than a hastily scribbled codicil made at the testator's bedside will be good enough to avoid falling foul of negligence and White and Jones claims. So a clear answer to that. If there's not enough time to get a capacity assessment, I think you still have to get the will made, because otherwise you could face a negligence claim. Okay, well that I think is all the questions. Thank you everyone for joining today. Please do check out our website for forthcoming attractions and also for recordings of our other webinars. I think some of them are also available on YouTube. And with that, I'll draw this to a close. Thank you very much, everyone.